And we are here today to discuss our rulemaking to implement Second Substitute House Bill 1515, which provides expanded alcohol service areas. We're holding today's session, and then we've got another one on Friday at 1 o'clock. The intent is to share the same information at both of these meetings, and we just wanted to provide different opportunities for your convenience to attend the meeting. You don't necessarily need to attend both, but you're certainly welcome to. There might be different questions that arise at each of these meetings. So our objective is to inform and obtain public feedback on draft rule language being developed to implement Second Substitute House Bill 1515, which creates 3 new temporary authorizations allowing for expanded alcohol service areas when certain conditions are met. And so let's see here. The best way to get in touch with us after the meeting or at any time really is through our rules at lcb.wa.gov. And you can submit questions and comments through that website this morning if you'd like, as well as the chat. And just a few kind of housekeeping notes here. These sessions will be recorded and are subject to public disclosure. The purpose of the recordings is to make sure we collect all the feedback, and it will be posted on the rules webpage. While the Teams chat feature will be on, any written questions submitted in chat will be saved in the rulemaking file and are subject to public disclosure. Questions and comments in the session's team chat will not be responded to in real time, but will be addressed at the end of the session, time permitting. Participants will be muted and will only be unmuted when the session's facilitator enables the microphone. And to ask questions during the sessions, please use the raise hand function. And then again, we have the rules at lcb.wa.gov as another means to get in touch with us. So what are we going to cover today? We're going to do a review of the legislation. We will talk about info available for applicants right now because the law is already in effect. We will go over the rulemaking process and our timeline, which is tentative. And then we're going to go over the draft rule, some key points, differences and comparisons. And then we'll get into the draft rule itself and just kind of go over some of the key points there. And then once I'm finished with my presentation, we'll open up for questions and comments from the group. So let's jump right into the review of the legislation. Second Substitute House Bill 1515 passed by the Washington State Legislature during the 2025 session. So that was, I believe, sometime in April. It was signed into law in May, and it took effect on July 27th, 2025. So that's nearly a month ago. As I mentioned, the law is already in effect. And this new law creates 3 new temporary authorizations allowing for expanded outdoor and indoor alcohol service areas. It requires new and amended LCB rules related to outdoor and indoor alcohol service, special occasion licenses, and catering licenses. And the law sunsets on December 31st, 2027, unless amended by the legislature. So while the bill clearly was catered to accommodate the FIFA World Cup in the summer of 2026, there are also much broader policy changes regarding alcohol service in public spaces, and there's a bit of a trial run aspect to it. There is a possibility that the legislature could vote to extend these expanded rules permanently, particularly, of course, if we don't see significant problems arise and it's deemed a success. But for now, these authorizations are slated to end by December 31st, 2027. So the first of these authorizations is expanded outdoor alcohol service in public areas for cities, towns, counties, port authorities, and unincorporated areas in a county. Local governments may request authorization for expanded outdoor alcohol service in public spaces in an area or areas of a city, town, unincorporated areas in a county or port authority for special events or an ongoing period through December 31st, 2027. The second authorization is for civic campus events in cities with a population of at least 220,000. So that really limits um, what this authorization applies to. I mean, we're talking about Seattle, Spokane, and Tacoma. I believe that would be it. These cities may request authorization for expanded indoor and/or outdoor events on publicly owned civic campuses through December 31st, 2027. And a publicly owned civic campus means that the buildings, facility, grounds, lands, and spaces are owned by a city. They must be designated as a city center and used for civic, arts, cultural, sports, or other community and family events and activities. They cannot be more than 100 acres in size, and the events are limited to 25 per year, and up to 7 of those may be multi-day events. And then the third authorization that this law creates is for the FIFA World Cup, which occurs in the summer of 2026. And it applies to fan zones and host cities. And that part of the law is only in effect for June and July of 2026. So it's just for 2 months while the World Cup is going on. And the cities that have been designated as fan zones are Bellingham, Bremerton, Everett, Olympia-Lacey, the Tri-Cities, Spokane, Tacoma, Vancouver, and Yakima. And then Seattle is a designated host city for the World Cup, and games will be played at Lumen Field there. So getting into the information that's available, as I mentioned, the law is already in effect. So beginning on August 27th, 2025, so that's a week away, applications for these authorizations will be available on the LCB portal. So the information is here on the slide. And then we have a new web page for all things related to these new authorizations at lcb.wa.gov/expanded-alcohol-services. And for licensing questions, we have a new email address at expandedalcoholservice@lcb.wa.gov. And so just to kind of clarify, we're going to be doing rulemaking for quite some time. I mentioned the rules at lcb.wa.gov. If you have questions related to rulemaking, please send those to us. But if you are interested in applying and you have questions about how to submit things or anything of that nature, your best bet is to reach out to our licensing staff, and you can do that through this expanded alcohol service at lcb.wa.gov. So the rules are currently under development, but we have a law that's already in effect. We're going to begin issuing licenses next week, but our existing rules don't support the new law. And in some respects, they stand in contrast or contradict it. And as we'll get into, rule development takes time. So in the meantime, the Liquor and Cannabis Board has issued an official policy statement to provide guidance in the interim between the law's effective date on July 27th and the adoption of rules, which are expected to occur in January of 2026. That the policy statement can be accessed through that additional information webpage that I referenced in the previous slide. just the lcb.wa.gov expanded alcohol services. So this brings us to the rulemaking process and our timeline. So rulemaking can be needed for a variety of reasons. Sometimes an agency sees an issue related to its mission that needs to be addressed, and the agency will initiate rulemaking on its own. However, rulemaking can also be necessitated by several other outside factors as well, such as public petition, executive order by the governor, state or federal court decisions, or legislative implementation. And the nature, scope, and even requirements for rulemaking vary somewhat in each of these cases. Today, we're talking about Second Substitute House Bill 1515, which makes this a legislatively driven rulemaking project. Our elected officials passed a bill which has now become law, and we are subsequently conducting rulemaking to ensure that the law can be implemented while adhering to our mission statement, which is to promote public safety, public health, and trust through fair administration, education, and enforcement of liquor, cannabis, tobacco, and vapor laws. So in this case, and any time that we're conducting rulemaking because of legislation, it's not an agency's role to debate the merits or feasibility of the law. Okay, that's already been done by our legislators. And we at the LCB and other state agencies, as unelected public servants, cannot change, expand, or diminish the scope and scale of the law that has been enacted. So what then is the point of rulemaking? Well, typically a given law will provide some degree of statutory authority to an agency to adopt rules that help to implement and clarify the requirements of the law. And in the case of the LCB, we also have relatively broad rulemaking authority over alcohol in general. So with respect to this bill, Second Substitute House Bill 1515, rulemaking is necessary to align existing LCB rules with new statutory allowances. And I would also add, create new rules pursuant to this new law. Rulemaking is also necessary to clarify ambiguity in the law and to establish appropriate fees as required by the law. And I have an asterisk there because there are very few instances within Second Substitute House Bill 1515 where the law explicitly defers to the LCB to adopt rules. It's actually pretty prescriptive already. There are several instances where it states that the LCB may adopt rules, but it doesn't require us to. And but one thing that is specifically required is that the LCB set fees to cover but not exceed the costs associated with implementation. So in order to comply with the law and begin issuing licenses as soon as possible, the fees have already been set based on our analysis of the bill and its implications in consultation between our finance division, licensing, IT, and the director's office. And the agency costs associated with this bill would primarily include licensing system updates and maintenance, as well as significant additional enforcement efforts that are going to be required. So the fees are pretty important information for folks applying. So I just put a slide showing these fees. So the expanded alcohol outdoor service areas, that's $1,700. The special occasion licenses for licensees would be $185 a day. The civic campus events would be $1,500 per event, and the fan zones would be $3,900 per event. So I mentioned that rulemaking takes time, so I won't subject anyone to actually audio of the carpenters. I just thought that was an appropriate slide there. The law took effect July 27th, and the LCB is complying by issuing licenses in a manner consistent with our most reasonable interpretation of the law. However, rulemaking is still necessary, and rulemaking takes time. Even the simplest projects often take several months to complete. And this is largely because the rulemaking process is bound by guidelines set forth in the Administrative Procedures Act, or the APA, that's Chapter 34.05 RCW, and rules designed to ensure public access and transparency in the process. The APA stipulates a three-part process for most rules and establishes minimum and maximum timeframes for certain aspects of each phase. For example, a required public hearing cannot fall sooner than 20 days following the filing of a CR 102, which is an official rule proposal. So getting into the timeline for this one here, we are doing stakeholder sessions this week. Of course, what have we already done so far? On May 7th, we initiated rulemaking by filing a CR 101, which is a pre-proposal statement of inquiry. That has to be done anytime you do rulemaking to start things off, to notify the public that we're going to be potentially changing rules. And then it was published on the 21st of May. And we established an informal comment period that ended on June 7th. And the draft rules and the stakeholder sessions were announced on August 1st. So going forward, after our stakeholder sessions this week, we tentatively plan to request board approval to file a CR 102, which is an official rule proposal with semi-finalized language, on October 8th. This will allow for that filing to be published in the state register by November 5th. And we would have a public hearing on December 4th. There are really strict guidelines. There's a cutoff calendar at the code revisor's office, which puts the state register on a 2-week filing schedule. So technically, we could have done the public hearing the week of Thanksgiving, the day before Thanksgiving. We thought that would not be in good form. So we're looking to early December to hold that public hearing, which would set us up to request board approval to file the CR 103. That's the permanent adoption of the rule by January 7th. And that would mean that notice would be published in the Washington State Register under WSR 2524. I think that might actually be missing a number there. Nonetheless, it would be published on January 21st. I also have 2025. That would be 2026. And then the rules would ultimately be effective 31 days later, which would mean the rules would be in effect on February 7th, 2026. And I would like to stress that this timeline is tentative. There isn't a whole lot of wiggle room there. So it's possible that things could get pushed out. But at the very least, we anticipate having rules in effect well before the World Cup takes place in the summer of 2026. So getting into the draft rule and some of the key points. Those in bold here are the new rules which provide for these 3 new authorizations. So WAC 314.03.210 is going to cover expanded outdoor alcohol service. 03.211 will cover civic campus authorizations, and 03.212 will cover fan zone authorizations. And then the additional new rules that we're proposing are somewhat ancillary to those 3 authorizations. And then we have 5 existing WAC chapters that need to be amended in order to accommodate the the new law. So that would be the caterer's license rules, rules for outside and extended alcohol service, special occasion licenses, and related rules to special occasions. So now we'll look at a few slides. Bear with me. I didn't want to throw a huge spreadsheet that's convoluted out there, so I just kind of chunked this out a little bit so we could take a look and compare what these various authorizations do. So looking at this slide, we see that the expanded outdoor and civic campuses, both are already in effect and run all the way until December 31st of 2027. The fan zones are only for those 2 months in the summer of 2026. They apply to different locations, as I've already discussed. So outdoor is allowed for expanded outdoor. The other two authorizations allow for outdoor and indoor expansion of alcohol service areas. There's somewhat of a difference between the localities and what areas can utilize these authorizations. You can see for the civic campuses, they can do 25 events per year, and 7 of them can be multi-day. The fan zones is just for that period during the World Cup, and the expanded outdoor, is much broader. So expanded outdoor would include beer, wine, spirits, restaurants, taverns, wineries, breweries, distilleries, snack bars, and then the civic campus and fan zones would cover all of that, as well as special occasion licensees and caterers. And there are some changes, minor changes to the rules for catering and special occasions as, when they are utilized under these authorizations. We can see here that there's some difference between the barriers. Looking at the barriers on slope, the statute states that that barriers are not required on a sloped site, and so we've added some rule language to accommodate that. It said that the barriers could be set by the Liquor and Cannabis Board. So I have a few things here in the table in blue, and that's because that's where the statute specifically gives authorization to the LCB to establish these things. And in this case, 42 inches was consistent with other regulations that we already have. So it made sense to add that here. That's the same thing with the openings to alcohol service areas. In the case of expanded outdoor, the localities do get to set that, but if they don't set that, then the default would be 10 feet. And then there are some differences and similarities between the signage that's required. And then we get into sharing an alcohol service area with other licensees and with non-licensees. And we'll talk a little more about the bottom row here, sharing with non-licensees, as we get into the draft. The version that we posted online doesn't exactly reflect that this is the case for civic campuses, but our understanding of the legislative intent and interpretation of the statute has evolved somewhat since the time that we posted the draft. So we'll be making at least a couple of significant updates to that. And then we have joint operating plan requirements for civic campus authorizations and fan zones. So all participating licensees have to submit a joint operating plan under those authorizations to be submitted to the LCB for approval. And it covers things like how to prevent underage sale and overservice, the ratio of service and security staff to attendees, training, the maximum number of drinks that can be served per transaction. That's another one where we have a precedent already for that sort of thing. So 2 drinks per transaction made sense there. And so then we can look at the comparison of employee assignments and the documentation that's required. They vary between the authorizations as well. So grounds for denial, the LCB does have some limited authority to deny the civic campus authorizations, but with the other, really, if the locality is meeting the requirements, there's nothing that the LCB can do to deny those authorizations. And for the civic campuses and fan zones, licensees are allowed to operate without the local permit that would otherwise be required. And they don't have to seek LCB approval for permission to share space and things like that. And then the last of this table that I'm sharing here relates to food service. So for civic campuses and fan zones, licensees will be able to sell and serve alcohol from alcohol service areas without food service, except required food service that's still required on licensed premises. And if there's already an existing alcohol service area that's operating under existing LCB rules prior to these new authorizations, that would still be in effect. So what I'd like to do here is I'm going to stop sharing my presentation and I'll pull up the draft rules and we'll just go over a few highlights. And then when I'm finished with that, we'll go ahead and open up for questions and comments. So just bear with me for just a moment here, please. No, sorry. There we go. Okay, so we've got the table here. We're going to really focus on the 3 authorizations, but we will cover a few things in the other sections as well. So we're first looking at, I mentioned that we have existing rules that we need to update in order to accommodate the new authorizations that are allowed under the law here. So looking at the caterers license, we just added an exception here for the new law. It says Chapter 361, Laws of 2025, and it shows the effective date there because different catering rules will apply if under these new authorizations. And then we had to update it a little bit as well to add these provisions for events at a civic campus authorized under the new WACs. Participating caterers must attest to joint responsibility as submitted by the campus operator and the local authority. Again, we're adding a few exceptions in here. And then at the bottom here, we are updating the fees. And that is not actually because of 1515. There was another bill that passed, 5786, during this legislative session that requires basically all of the fees that are administered by the Liquor and Cannabis Board to be increased. And so since that is already in effect in the law as well, we're just going ahead and updating those as part of this rulemaking. And then moving on to the existing outside or extended alcohol service rules, we just plugged in an exception stating that this rule does not apply to outdoor expanded alcohol service authorized under the new law. So getting into the first new rule section, we have the expanded outdoor alcohol service authorization. So section 1, we have definitions. Those are pretty self-explanatory. Under B, licensee, it clarifies exactly what that means. So who can take advantage of this authorization? And then it defines what a local jurisdiction is, which, as mentioned before, is a city, town, county, or a port authority. So section 2, the expanded outdoor alcohol service authorization described in this rule allows licensees within a local jurisdiction to share an expanded alcohol service area with other licensees subject to the requirements in this rule. So it does not apply. Here we kind of cross-reference this. It doesn't apply to the existing rules. And B, it state 2B, licensees may share use of an expanded outdoor alcohol service area with businesses that do not engage in the sale or service of alcohol, subject to the requirements of WAC 314.03.215. And so that's referencing one of our new rules that I mentioned, kind of ancillary to these 3 authorizations. There's a new rule covering requirements for when a licensee shares an alcohol service area with a non-licensee. So there's a board notification requirement there. And then you'll see this kind of across the board with these new authorizations. All participating licensees are jointly responsible for any violation or enforcement issues, unless it can be demonstrated that the violation or enforcement issue was due to one or more of the licensee's specific conduct or action, in which case the violation of enforcement applies only to those identified licensees. And a lot of this rule language, this in particular here, 2D, comes, almost verbatim from the statute. Like I said, the law is already fairly prescriptive, but there are a few areas where we did feel the need to clarify and do have statutory authority to do so. So again, this could be the entire local jurisdiction or specific areas within it, and that's determined by the locality. There is a point of clarification. A county can only be approved for authorization in this rule as to the unincorporated areas of the county. So for instance, in Thurston County, the county can't implicate the city of Olympia, right? Even though it exists within the county. So for a local jurisdiction that requests approval from the board for an expanded alcohol service authorization, as described in this rule, shall submit documentation of the following. And then we kind of go through how local resources will be allocated regarding law enforcement patrols. And then B, how are we going to keep things clean with this expanded alcohol service, right? So that's also in the statute. Those were items that were deemed important by the legislators. So getting down to C, identifying the maximum distance apart for openings into and out of expanded outdoor alcohol service areas. I mentioned that earlier. It is up to the locality, but if they do not stipulate in their application, then the 10-foot opening would apply. And again, that's just consistent with other existing liquor and cannabis rules. So the local authority is responsible for updating the board on changes. And then 6 all expanded outdoor alcohol service areas must be enclosed by one of the following. So a permanent or movable barrier at a minimum of 42 inches of height. So here's one of the places where the rule that we posted online hadn't been updated with kind of new information and our evolving understanding of the statutory intent here. So the 1515 clearly states that a permanent or movable barrier doesn't have to meet those height requirements if there's a sloped conditions. So I just kind of took a stab at it here. We might massage the language somewhat, but I just added naturally sloped conditions approximating a barrier of 42 inches or greater may be considered a permanent barrier. Hopefully, we don't necessarily want this alcohol rule to read like a building code that you need an engineer to understand. But if we need to kind of flesh that out a little bit, we certainly can do so. So a permanent fence-free demarcation is also permitted. And then if that is used, there are requirements under 6C for that. So it would have to be at least 6 inches in diameter. I've heard these referred to as turtles. I don't know, but they have to be placed no more than 10 feet apart, and they would have to be visible at night if you don't have a fence or a permanent or movable barrier. And
Hey,
yeah,
Kevin, would you
yes,
mind just making the text a little bit larger?
absolutely. I apologize for that. Is that better? How
Yeah,
about
that's
that?
better. That's better on my screen anyway, but
Okay, there we go. And then 7 covers employee assignment in the alcohol service area, stating that an employee of the licensee must always be assigned to the expanded outdoor alcohol service area when patrons are present. When an obstructed direct line of sight from the licensed premises to the outdoor alcohol service area exists, an employee with a mandatory alcohol server training, that the mass training permit under Chapter 314.17 WAC must be present in the expanded alcohol service area at all times that patrons are present in order to monitor alcohol consumption. The expanded outdoor alcohol service area must be within sight of an exterior entrance of the licensed premises. So it doesn't have to necessarily be the entrance, but anywhere on the licensed premises, they have to be able to see it. And then under 9, a local jurisdiction approved for an expanded outdoor alcohol service authorization consistent with this rule must submit the results of a public engagement review consistent with WAC 314.03-14. So that's in the statute. Any jurisdiction participating in these new authorizations are required to conduct a review and submit the results of that to the Liquor and Cannabis Board as well as to the legislature. And then we've added the fee in there that we discussed earlier and the effective date here under 11. So that covers expanded outdoor. And we'll move on to the civic campus authorization. So again, we have definitions. They're somewhat self-explanatory. The licensee here, it's important to note that this is special occasion licensees and those licensed to do catering will be able to take advantage of this for civic campuses as well, whereas in the expanded outdoor authorization, they are not. We define what a publicly owned civic campus is, and that comes directly from statute. Here we're clarifying, that this is for cities with 220,000 inhabitants as well. Again, that would be Seattle, Spokane, and Tacoma. Under 2A, that's the 25 events per year authorization. And then under B, 25 events may be multi-day events. It wasn't clear what a multi-day event was, so a 7-day event seemed reasonable. Anything longer than that would be a multi-week event, so 7 days seemed appropriate there. And then we go into rules, related to multiple licensees on Civic Campus. It's talking about sharing alcohol service areas. So it can either be the whole place or a designated portion of that Civic Campus. The board has to approve the perimeter of the alcohol service area, and security and physical barriers have to be provided at all entry points. We have to be notified at least 60 days before the event begins. And then under D there, signage has to be conspicuously posted during the event, notifying the public that the area is in use as an expanded alcohol service area, and public notice of the upcoming use of the area as expanded alcohol service area was conspicuously posted at least 7 days in advance. E goes into the joint operating plan that's required. And again, we have ancillary rules related to the joint operating plan in WAC 314 03 to 13. And here's where, again, the draft that we posted did not provide for this, but we had some questions. The statute doesn't really explicitly state that on civic campuses, licensees can share space with non-licensees, but our interpretation of a civic campus would inherently mean that licensed businesses would be sharing space with non-licensed businesses. So we added this provision, or again, this isn't, this was just something that I added in there to accommodate for that, to let everyone know we are going to be amending the rule, but we may modify that language somewhat. But it states that businesses that do not engage in the sale or service of alcohol are located within the perimeter of the approved alcohol service area. Licensees must also follow all requirements in WAC 314.03.215. So again, that's the ancillary rule related to sharing, licensee sharing an alcohol service area with a non-licensee. And then 4 goes into licensees sharing an indoor space. And again, there's a 60-day notification requirement. There's requirements for security and physical barriers. There are the joint operating plan requirements. And again, here under 5A, we see that same provision basically saying that everyone in the alcohol service area is responsible for what's happening there, unless we can pinpoint that there was a violation specifically stemming from one licensee, for instance. There will be an attestation under 5B. So any licensee that's going to participate in the Civic Campus authorization will have to affirm that they are going to be taking part. And under 6, it stipulates that while they are operating under this authorization, a licensee can operate without a permit from their local jurisdiction that they might otherwise be required to have. Let's see here. And they can also share an alcohol service area with another licensee without individually requesting that approval from the board. And regardless of whether the licensees property parcels or buildings are in direct physical proximity to one another. So that's a little bit different than some of our existing requirements. And then they would be able to sell and serve alcohol to customers from an alcohol service area without offering food service menu options, unless they're otherwise already required to.
Kevin? Kevin, there's a question in the chat, and I don't know if you want to take those questions now or wait until the end.
Yeah, I was planning to wait till the end.
Okay.
Yeah, I'm sorry. Sharing my screen, I can't see the chat either. So just bear with me if you don't mind. We can circle back to your questions once I'm done here. All right, so moving on to 8. Again, there's the requirement for a report submitted to the legislature and to the board by a city that is taking advantage of this authorization. And then we have the fees and the effective dates. And then the last new authorization here is the fan zones. You'll see a lot of it is, very similar. We've got definitions. The special occasion licensees apply here as well as the caterers. And then it stipulates, the time frame is only for the 2 months in June and July of 2026. And then 3 talks about sharing with other licensees as well as non-licensees. The board has to approve the perimeter under 3A. The same security and physical barriers requirements are going to apply as for the civic campuses. So again, here we have to have notification 60 days in advance. There are the same signage requirements as well. They have to be posted 7 days prior to the event. And then there are the same requirements for the joint operating plan. And then again here, I'm sorry, I mentioned sharing with non-licensees. That's covered here under 4A. And that refers us to WAC 314.03.215, which is the new rule specifically pertaining to sharing space with non-licensees. B, there, again, we have that joint responsibility provision. There's a requirement for licensees to confirm their participation by an attestation, similar to what we have with the civic campuses. And then again, while licensees are operating under this authorization, they can operate without a permit from their local jurisdiction that would otherwise be required, and share alcohol service areas with other licensees. They don't have to request individual approval. And the requirement that they have to abut the other licensees' businesses or property doesn't apply under this authorization. And then again, those provisions related to food service. For this one, again, the fee is $3,900, and this one only runs through August 1st of 2026. So those are the 3 primary authorizations. Then we have the joint operating plan. So, here we see that that's required for the civic campus authorization, and for the fan zone authorization, it doesn't apply to the expanded outdoor authorization. And then there's some guidelines for how the joint operating plan has to be submitted. Again, that portal will be open starting next week. The fan zones, again, that doesn't that won't occur until the summer of next year. But the authorizations for the other two that are in effect will be available next week. We have to have notification 60 days in advance. We are going to want to see under 4A how the licensees will prevent the sale and service of alcohol to persons under 21 years of age. And then under 4B, that's related to overservice. We want to make sure that there's a plan in place to make sure people aren't being overserved. So the statute requires also that the ratio of alcohol service staff and security staff to the anticipated number of attendees is included in the joint operating plan. In this case, the statute does give statutory authority for the Liquor and Cannabis Board to set those ratios, but we did not deem that it would be appropriate to do so because it's not really a one-size-fits-all number. In some cases, one ratio might make sense, and others they might not. So the really due diligence falls on the locality that's applying to assess what they have and what their needs are, and to determine what that appropriate ratio would be. Then there's training requirements. Of course, we'll also want to see the licensee's policy on the number of alcoholic beverages that will be served, not to exceed 2 alcoholic beverages per transaction. So it could be limited to 1 if you wanted to, but not to exceed 2. And then we'll want to see an explanation of the containers. So, we'd want to see that there's some sort of difference so that we can easily identify an alcoholic beverage as opposed to a non-alcoholic beverage. And then there's barriers requirements. And under H, there's various provisions there. How will licensees maintain separate storage of products and separate financial records? If they share any point of sale systems, they have to show how they're going to independently maintain complete documentation and records for their distinct business operations. And then the joint operating plan will have to include a map of the alcohol service area. And the map will have to include certain provisions, indicating what's north, so that we'll know specifically where it is, what locations that alcohol will be served at. The map should show the barriers, any sloped areas if applicable, and where the entrances and exits are, as well as public streets adjacent to the alcohol service area. So again, I don't think we necessarily need to get into the weeds on the public engagement review. I've already covered that. Any locality participating in these new authorizations will need to conduct a review and submit that to the board and to the legislature by September 1st of 2026. And I imagine the legislators will use that information to determine what, if anything, to do going forward. And as mentioned, we have a section here regarding licensees sharing alcohol service areas with non-licensees. The Liquor and Cannabis Board does not regulate non-licensees, but we do regulate those who are licensed. So there are certain expectations there. And then here under 2B, again, our initial draft did not provide for sharing of space with non-licensees on civic campuses. However, we are going to take a more permissive interpretation of the statute there. So licensees will be able to share space with non-licensees. So I added the pertinent chapter there. And then we get back into the existing rules that we already have, and just making exceptions that kind of carve out to allow for these new rules under second substitute House Bill 1515. So I think that pretty much covers it. There are specific exceptions here for the application process, because a special occasion is going to be different for under these new expanded alcohol service areas as they would be under normal circumstances. So again, I don't need to necessarily read the existing rules, but the changes here are highlighted. And again, those are just exceptions kind of carved out for the purpose of accommodating the new law. So I believe that takes us to the end there, and that took me nearly an hour to get through. So we've got about an hour here for questions and comments. So I'm going to go ahead and stop sharing. And Denise, we can go ahead and take public questions at this time.
So there are a couple questions in the chat. If you could look at those maybe to
Sure.
start with.
Okay.
Yeah, if they can get explained.
So Gretchen Linehan, WAC 31403-211, do non-licensed businesses also sign the attestation, or is it sufficient that the non-licensed business is incorporated into a joint operating plan? I would defer to our licensing folks, but I'm pretty sure that since we do not have regulatory authority over non-licensees, that they would not be required to sign the attestation. I think that's just going to be for licensees. If anyone on the call in licensing or enforcement interprets that otherwise, please chime in. Okay, so moving on to the next question, your slide stated that applications for the new authorizations will be available on the LCB's portal starting on August 27th. Are these applications for the localities themselves requesting the authorizations only, or are they for existing licensees too? Are you able to provide a demo showing how to apply for one of the new authorizations in the portal? If not, will the LCB make application previews available so applicants know the exact information that will be required? Will authorized representatives be permitted to apply for new authorizations on behalf of clients? So I don't have the ability to show a demonstration of the portal today. I did mention the email address for questions for licensing. So that might be an opportunity to reach out if you do run into any questions. And as far as I understand, authorized representatives would be authorized to apply for new authorizations on behalf of others. And again, if our licensing folks, a lot of this information, we've been kind of hurrying to get everything together. The bill became law pretty quickly, and we've had a tremendous amount of rulemaking work going on, as well as implementing other things. So I'm operating on my best understanding of how licensing is going to do this. But if anyone on the call understands things otherwise, please chime in. Is there a special team at the Washington State Liquor and Cannabis Board that will be responsible for reviewing and approving all applications related to these new authorizations? If so, can you say who? That would be our licensing division. They will be reviewing all of those applications. And again, if you have questions, you can reach out. Thank you, Justin, for adding that expanded alcohol service at lcb.wa.gov. That webpage also includes the email address for our licensing staff to reach out to them if you have any questions. And will the Washington State Liquor and Cannabis Board be publishing a joint operating plan template that licensees can use, similar to the alcohol operating plan template the Washington State Liquor and Cannabis Board developed for use by sports entertainment facilities licensees? I'm not aware of a template that is being developed at this point. It is my understanding that in the portal, it will kind of prompt you through those things. But again, that would be a question for our licensing division. Really, our focus here is the rules. We're looking for questions and comments related to the actual rule language. And as far as efforts to obtain a license right now, you'll need to reach out to our licensing staff. So that covers no, it does not cover the questions in chat. Let's see here. In a sip and stroll zone, would customers be able to take alcoholic drinks and glassware bought in one restaurant into an outdoor area into another restaurant? So it's my understanding that yes, if both licensees were included in the alcohol service area, and they were both part of that joint operating plan, that would apply. And I see there that Desiree from our licensing division has indicated that yes, we will be publishing a joint operating plan template. The fan zone authorization applies only during a single multi-day event in each fan zone during the specified time period. In the civic campus section, multi-day is defined as 7 days. Does the 7-day definition apply to fan zones? The answer to that is no. The fan zone authorization would be for the entire 2 months that the World Cup is occurring, or if a locality wanted to limit that further, they would be welcome to do so. But it would be up to those 2 months. But the 7-day definition would not apply there. That's only for the other authorization. Will there be maps to clarify locations for zone? So we're asking that localities who are applying for these authorizations to provide a map of where they want the alcohol service areas to be. And in the case of the civic campuses, the Liquor and Cannabis Board has authorization to review that and approve that. And the other 2 authorizations, it's up to the locality to determine where the alcohol service area is. Our applications open August 27th for municipalities, for individual businesses, or both? Might have missed that answer. I believe that it will be both. So like the special occasion licenses that will be uniquely authorized are under these new allowances will be available starting on August 27th. And then in areas where the requirement for security is mentioned, are there guidelines for what defines security? And again, so we defer to the localities to determine what is appropriate security for their particular locations. So it's really kind of not a prescriptive standard, but a performance-based standard. I mean, the localities will determine what they think is appropriate, and then they're going to have to submit a review of how things went, right? So if if they kind of missed the mark and it looked like there were issues resulting from that, that could result in a denial moving forward or things of that nature. Okay, and let's see here. The LCB licensing division will be conducting a review. So I'm a partner at Foster Garvey, and we have many clients interested in these authorizations. I'm expecting to have many detailed questions that will likely need supervisory review. Be helpful to know who within licensing is going to be the ultimate decision makers regarding these authorizations. So again, I would defer to our licensing staff. Really, the focus here is to make sure that the rules in place make sense. And we're trying to provide as much information as possible, given that licenses will be available starting next week. But I can't answer specific questions related to how licensing is going to do some of these things. And I see where Desiree did add a contact there, so that should be helpful to folks asking those questions. We've got a phone number and email in the chat. All right, so I don't see anything else in the chat.
There was, Kevin, there was one more question about
what did I miss?
the drop dead date for submitting feedback for incorporating into the final rulemaking.
Okay, so I'm sorry, I didn't see that. Oh, there we go. Okay. So after these stakeholder sessions this week, we're going to take all of your feedback and we're going to incorporate that into the rule as we deem appropriate. And as I mentioned, we're looking to file the CR 102. That's the official proposal in October. I believe it's October 8th. But there are still opportunities at that point to provide feedback. So I would say, the earlier the better, but rulemaking is inherently an open public process. So, if you get your comments into us by the end of September, the sooner the better. Again, there's the likelihood that we will be able to incorporate that into our rule proposal, which will be hopefully filed on October 8th. And then at that point, when we file the CR 102 rule proposal, we will announce a public hearing. That will be a few weeks following the rule proposal. Like I mentioned, right now we're looking to do the public hearing on December 5th, I think. And so we would still continue accepting comments, but at that point, once the 102 has been filed, those would be more formal comments that we would then incorporate into the rule file. They would be subject to public disclosure and that sort of thing. And then you can testify publicly at the public hearing if you still have comments at that point. And then if those comments warrant additional changes, then we would either have to, if they're minor or insignificant changes like grammar or formatting or something like that, we could probably do that without filing a supplemental CR 102. We would just have to respond in what's called a concise explanatory statement and identify where the adopted rule is different from what was proposed. So to answer your question, I would say, feedback is always good. The earlier, the better. But there's going to be plenty of opportunities, at least up through December, to provide feedback on the rule. Okay. So I see Denise, thank you for providing a response to that last question there regarding the rulemaking information. And I don't see anything else in the chat here. So are there folks who are raising their hand that would like to ask questions? I'll just give it a few minutes. If anybody wants to raise their hand and ask questions or have a discussion about any aspects of the draft rules, we are here to do so. I do see Desiree, thank you for jumping in there as well. So we will be adding GIS maps available after the map has been submitted by the locality. All right, and Nicola kind of clarified it a little further there. For expanded outside services, the local jurisdiction would need to establish the areas prior to licensees applying. Right, so if there is no alcohol service area in place, there's nothing to apply for yet. Are we able to get a copy of the updated draft rules? So we will update the rule and post it on our rulemaking webpage. And that should probably be done by the end of the week here, or shortly thereafter. So we'll evaluate the feedback that we get today, as well as the feedback on Friday. Again, I'm gonna do the same presentation. So it's going to be a lot of redundant information, but we will get the updated draft posted shortly. Okay, we'll just give it a couple more minutes, in case any thoughts come to mind, any additional questions. Okay, to the extent that the right-of-way might be included, in an alcohol service area, does the LCB have anything to say about that? Or is that all on the local jurisdiction? Yeah, as far as I understand, that would be determined by the local jurisdiction. Would restaurants be expected to use eco-friendly disposable glassware in these areas? I don't think that, yeah, so we do not have any regulations requiring a specific type of disposable glassware. If we currently have a snack bar license, do the specified expanded service areas as defined in the new WAC apply now? It would only apply if you are authorized under that joint operating plan, right? So a snack bar would have to be included and attest to their participation in the expanded alcohol service area. Okay, so it looks like yeah, Nicola provided a little more clarification on the snack bars there too. You could only sell what you're licensed to sell, but patrons could be present that have other alcohol types from another establishment. It does look like the questions are kind of have come to an end here. So I'm going to just once again drop our rules at lcb.wa.gov. That's the best way to reach out to our rules team for any additional comments or questions about this, the draft rules here. So I think we'll go ahead and wrap it up. Again, we're going to be meeting on Friday at 1 p.m. to cover the same material. So you're welcome to attend. Again, it's going to be a lot of the same information, but we will continue evaluating all the feedback, and then we'll be working following this week to incorporate feedback as necessary into the draft rules in preparation for an official rule proposal that we are looking to file in early October, which puts us on track to adopt rules in January and then have them effective in February of 2026. Let's see here. Is there anything else that I didn't cover? I think that pretty much covers it. So we'll go ahead and conclude today's meeting. I really appreciate everyone's questions and participation. Please reach out to us at rules@lcb.wa.gov if you have any questions about the draft rules or if you have suggestions about changes that should be made. So again, thank you all for your time today, and I hope you have a great rest of your day. Thank you all so much.